Most people terminate the contracts of their domestic workers, commonly referred to as house helps, without any notice. But did you know that the house help who we employ at our homes are supposed to be handled like any other worker, thanks to the Employment Act 2007? Now, like any other employee, the domestic worker is entitled to the statutory minimums, which include an annual leave of not less than 21 days, 7 days sick leave on full pay, and another 7 days on half pay, and at least 90 days for maternity leave for females, or 2 calendar weeks is paternity leave for males. Domestic workers are also entitled to at least 1 rest day every week, overtime, and their remuneration must not be less than the prescribed minimum wage, currently at 10,955 shillings for those working in Nairobi, Mombasa, and Kisumu. Domestic workers have the right to form and join trade unions of their choice.
One of group of employees or workers who are not probably aggressive at urging their rights, and also whose rights are abused by the employers most of the time. The reason for that is probably because they're not enlightened, and the fact that they occupy a place probably in the house or a domestic situation that is not properly, is not given credence, is not viewed as an important role in the house. It is a very important role for the growth of the family and probably the stability of the family.
However, a majority of workers in this sector are not members of the union due to fears of victimization from their respective employers. When terminating the services of a domestic worker, you are required to offer valid reasons as to why you are terminating her services and pay her all her dues.
If the employment is month to month, or it is continuous for more than a month, and therefore the wage is paid every month, they be deemed in law under the Employment Act as permanent employees.
However, due to scarcity of employment opportunities, most house helps tend to endure harsh working conditions in order to get a meal and be able to provide for their families.
Meant to stay or leave, and therefore if she falls sick, the employer is duty bound to take the domestic worker and therefore the employee to hospital, or provide medical facilities or a medical card, and foot the expenses of that treatment. Termination has to be in writing, must be in writing. That's the provision of law, and a certificate of employment must be provided for, and the benefits against that termination must be provided. For instance,
although their rights are stipulated in the Employment Act 2007, most of the domestic workers do not exercise or enjoy their rights.
These are people who probably need to be enlightened more, probably with more civic education on their rights in as far as employment. The Employment Act is concerned. Most of them are ladies, and therefore I believe if NGOs could retain part of the obligations towards enhancing the rights of domestic workers. Now, if a domestic worker has been terminated or treated unfairly, can possibly retain an advocate, who then will want to charge some fees. So if they think that is probably not part of their what they can afford, then they could go to the labor offices. The labor offices will obviously take up the matter on their behalf. They have 2 advantages if they go to the labor offices. There's a prosecutorial aspect. It's criminal not to abide by the terms and conditions stipulated in the Employment Act, and also they can compel the employer to make payment within the law.
Well, there you have it. Before you terminate the services of that domestic worker, make sure you give him or her a 1-month notice. That is according to Employment Act 2007. For Business Insight, I'm Dzuya Walter.